because it's rapidly progressing. One of the things that we know in human resources is what employees can expect of the company and what the company can expect of employees. Employee handbooks are one of the most critical tools that we have, and this is the time of year when we suggest employers look at their handbook to see if it's concurrent and contemporaneous. It's important to know what's in your employee handbook. And it's interesting as dealing with a lot of clients who have personnel problems, questions, legal challenges, and so on. The handbook is designed to be the first place you look for help and guidance in answering these issues. It's also important to have a policy of following what your handbook says. It's been said that the only thing worse than not having a handbook is not following the handbook that you've already adopted. It's also important, and we know this particularly in California, that policies, rules, laws, regulations change. In fact, the Cal OSHA Standards Board is meeting today to talk about the successorship for a COVID OSHA safety policy that would be effective the 1st of January of 2023. So hopefully between now and the next couple of days, we know what the rules are, because the current emergency standards for COVID expire at the end of December. It's also important that employees know what we're trying to do. So what is an employee handbook? An employee handbook is a set of company policies and rules for working at your company's operation or your organization. It provides guidance to employees on issues of performance and behavior. It guides supervisors and managers in handling employee issues. And let me just stress, this is an important concept not to overlook, to make sure that periodically you do meet with and discuss with your supervisors and managers what's in the employee handbook, particularly that's important to them in directing and guiding and supervising employees. The handbook also contains provisions required by California and other laws. So important aspects of a handbook. It must state the legal responsibilities and rights for the employer and the employee. And I will say part of this is it's a legal document, even if it isn't a contract. And we go to efforts in most handbooks to say this is not a contract, because it does need to be able to be modified and changed as circumstances change. But it's going to clarify what employers expect of employee behavior. And for example, whether people are to be at work on time and the consequences of being late to work and telling their supervisor or manager if they're going to be late is a common problem, but can be dealt with by the handbook. Many of you know that there are legal penalties if you don't provide rest breaks or meal periods to employees who are hourly employees. Creating an expectation and stating the rights of employees that they have a right to have meal and rest breaks is an important part of your handbook. Handbooks can also be an important part of your company culture. Now, that's only true if you, one, think about your company culture in writing your handbook, and number two, you use the handbook and remind and educate employees about it. Also, California and federal law requires providing a safe workplace. So you can deal with employee safety and health issues in your handbook. And increasingly, we're looking at violent prevention or violence in the workplace in a handbook. So there's some specific changes that you need to make in your handbook for 2023 if you haven't done it already. One is that we have a new, what we call protected class or rights group, such as age, sex, race, religion, national origin. And we have now, under California law, made reproductive health decisions as a protected class. And so in your equal opportunity provisions of your handbook, this is an important thing to consider. We've also expanded the right to take paid sick time under the California paid sick law, as well as the family medical leave or California family rights leave, so that when we say you can have time off to care for yourself or for your family members, Family members now include an opportunity to designate one person who is not a technical family member, but is treated and considered to be a family member for having use of paid sick time or having leave to care for such persons. Because of the changes that have occurred, you can combine your California Family Rights Act leave and your FMLA leave. Now, FMLA applies to companies with 50 or more. California Family Rights Act applies to companies with 5 or more. Because of the effort to have a handbook that's not 100 pages long, and considering the FMLA and CRFA policies often take several pages, you might want to take this opportunity, if you haven't done so, to combine those into one policy. And the California Family Rights Act, just as paid sick leave, can add as a designated person as someone an employee can take time off to care for. Another issue, which may or may not be important to your company, is the requirement now, if you have 5 or more employees, to provide bereavement leave of up to 5 days. Bereavement leave does not need to be paid, but most people's previous bereavement leave handbook policies need to be looked at because likely they need to be tweaked somewhat to comply with this new law. And there's a new provision for occupational safety. When there's an emergency disaster condition or crisis or crime activity, such as fire, earthquake, and so on, an employee can take time off to be safe to leave a dangerous workplace. And so how that's worded is important for your handbook. And virtually no handbooks up to now had had a provision like this. So without an employee handbook, most employers do not fulfill all of the obligations of California law. And so we suggest a handbook, even if you only have 1 or 2 employees, because it's a place where you can meet these legal obligations. If you have employees in multiple states, you may choose to have one handbook or supplements for the various states, because increasingly there are different rules, such as meal and rest breaks, overtime, forfeiting of vacation pay, which isn't allowed in most states, but is in some. All of those things, you can have different policies in different states if you wish, or you could adopt one handbook. And this is always a challenge for employers who have employees who work in multiple locations. It's also now a challenge for employers that have employees working remote. If those employees who are working remote live in another state and are working for you from their home, which is not California. So equal employment and anti-harassment policies need to be provided. You need to state pay periods and pay dates. You need provisions on rest and meal periods for hourly employees. Availability of a variety of leaves of time off, which differ by the size of the employer. You need to have paid sick leave, a written safety plan, and personnel file access. All of these things you can handle in the employee handbook. Excuses for not having a handbook. Some people say we're too small to justify the creation of a handbook. Wrong, because some of these policies apply even if you have only 1. I just completed a handbook for an employer with 2 employees, and I was able to keep the length of their handbook down to 9 pages, which is pretty good these days. But even that company with only 2 employees needed to have those provisions of law. Some people say a handbook might open us up to problems of lawsuits. That's wrong, because the handbook, if it's written carefully, is your best way to avoid misunderstanding and a defense for employee-related claims. Some people say it costs too much to have a handbook or to have people help us. Realize the consequences of not having a handbook. An average employee lawsuit will cost a company $200,000. Now, this is companies who do not have employment practices liability insurance, but even EPLI insurance often has a deductible of $10,000, $20,000, $50,000. In the average lawsuit, there's about $80,000 spent to pay your own attorney's fees to defend a case. And this is even if you win. On the other side, it costs $80,000 or more to handle and pay for employees' attorneys. And Settlement costs in the range of $40,000 per claim, and this is obviously an average because different circumstances differ. The average is not a good benchmark, but it does give you a good idea of the protective value and financial value of having a handbook. Why get help? Because a poorly drafted handbook can lead to legal claims of discrimination, failure to provide certain rights such as meal and rest breaks, wage violations, discrimination complaints, and so on. Using an experienced HR person or attorney will take less time and less frustration. And frankly, my suggestion is that you don't try to do it yourself, but you could make notes of what you cover in a handbook and then have someone who's knowledgeable do it. I can't tell you how many times I've talked to employers who had all the best intentions and started writing a handbook and found it was so complicated that they gave up the effort. The other part is don't rely on model handbooks, particularly from national payroll firms like ADP, because they do not often include provisions that are specific to California law. And if you go on the internet and you said employee handbooks, you can find models or drafts to use. You can pay tens to hundreds of dollars for those, and they may or may not be what you need in California. A handbook is not a contract. It's important to put a disclaimer in the handbook itself that says this is a policy guide, not a contract. It's also clearly to state how you can amend or update or change your handbook. Statements at will are important. Now, California and other states are what we call an at-will state, meaning you can terminate an employee or an employee can quit for any time or any reason or with no reason. The problem is that this statement of law has been eroded by hundreds or dozens of court cases. And so if you want to protect your right to exercise at-will employment, you need to say it, and you need to say it carefully. There are certain words that are important to include to protect that right. One of them is that if you have a right to amend your handbook, you will not amend your at-will policy, because there have been courts that said, if you have the right to amend your handbook anytime, and that includes the at-will policy, then you don't really have an at-will policy because it's not clear and certain. So that's why wording becomes important. You can give an employee, and often should consider giving them an offer of employment, which is a contract. And also realize if you're hiring hourly employees in California, there's certain information that must be disclosed at time of hire, some of which are in your employee handbook if you have one. Provisions that should be included in a handbook. And this is just to give you an idea of the types of things that are important. Most important these days are non-discrimination and prohibition of harassment, as well as how an employee can make a complaint if they're experiencing this. Because this is a requirement that you have these policies, and the policies don't protect you if you don't have a clear complaint process. But if you do have a complaint process and you use it, it can provide important protections for you as an employer. There need to be leave of absence provisions, and the leave of absence provisions to some extent depend on how many employees you have. So one of the things that a handbook preparer will often do is say, how many employees do you have? And that is because there are rules that apply if you have only one employee, if you have two, if you have 5, if you have 15, if you have 20, 25, 50, 75, or 100. So the different types of rights of leave of absence depend on how large your company is. Paid sick day is now a part of California law, and how that works should be described. We are strongly recommending there be attendance and punctuality rules and what we call a no-call, no-show process. There are very important times when you're having a problem of behavior with an employee, and the reason that you need to take care of it is that they're not reporting to work or telling you when they're missing work. That can become a voluntary quit, so you're protected against termination, lawsuit, wrongful termination cases. You also have proof that the employee saw the handbook. There are a variety of ways to do this, electronically or on paper, but a recent California court said, for example, an important clause in a handbook didn't show that the employee had actually seen or knew about it. and therefore wasn't valid and didn't provide protection to the employer. They're also important to have a statement that people can have access to your illness injury prevention plan or a written safety plan. So it's important to have a plan, but also to have employees be able to request a copy. Other provisions to consider. Welcome to new employees. A description of your company history, because these are important things that can help create and maintain your company culture. What is the nature of employment? And the company has a right to change job duties, hours, or working conditions, because some employees will say, I was hired to do a certain job and now you want me to take on additional duties, and that wasn't part of the offer of employment. Well, one of the ways to handle that is a handbook policy that says we have a right to change your duties and working conditions. You may want to have a provision about compliance with immigration law and the ability to produce documents that show an employee can work lawfully in the US. This would depend on whether you use the I-9 form process or the E-Verify process. Many companies want to have classifications of employees, such as regular, part-time, temporary, employees on leave, probationary employees. And this is a great way of clarifying to people what their expectations are. Many employers want to have an ethics provision, because ethics and the way you do business, the way you treat your customers and each other can be important. Some employers want to have policies on restricting outside employment. You can't prevent outside employment, but you can provide that it does not interfere with the duties of the employee working for you. Some companies want to have dress codes because it's important to them. Other companies, this isn't a big consideration, but if it's an area to consider what you'd like to do. And another part is how to handle a termination of employment, even a provision that asks an employee to give you notice. We can't require them to give notice, but we can encourage it by having a process for handling ending of the employment relationship. Many companies want to include policies on confidentiality and business secrets, or if you're in the medical area, maybe patient information. Some companies have very detailed and specific employee conduct rules and how discipline is handled. This is an issue that's subjective for each company, but a handbook's an excellent place to do it. Drug and alcohol policies are important. And as California has changed in our relationship with marijuana, how we deal with marijuana has changed. In fact, in 2024, there are new restrictions to protect employees' off-duty use of marijuana, whether it's for recreation or medical purposes, and how employers can test for people being under the influence or being impaired in performing their duties. So this is an area that you need to think of, and if you don't want to deal with it now, certainly between now and January 2024 is an area you should look at. Many companies have a policy on company property. Company property just gives you the right to clarify that employees have to take care of and not damage your property, as well as your right to inspect company property, tools, lockers, desks, because if you're concerned about employee theft or misconduct, you may need to conduct an investigation. The use of phone and computer equipment is very important, and there are a lot of policies that can go into this. Respecting the right of the owner of the software, expressing the employees don't have an expectation of privacy so that you can monitor it when you need to, that people should not use or should use their own phone or company phones for personal business, how you pay people for use of personal phones for company business. Also, part along with termination of employment is the issue, how do you get property back? Because there are difficulties in getting back tools, phones, computers, etc., if you haven't clarified what the expectations and process are. And you can't necessarily just hold up an employee's last paycheck to get this back. You need to think through what are the legal processes to getting company property back. We also think it's important to have an expense reimbursement process because employers are required to reimburse employees for reasonable expenses that are incurred necessarily in performing their job for the company. Well, that's a nice statement, but what does it mean and how does an employee file an expense report. And I can tell you there are clients of ours who have employees 2 to 3 years later who are coming back and asking for reimbursement of expenses that were never mentioned or brought to the attention of the company while they were working there. That's partly because there may not have been a well-written expense reimbursement process. Also, rules for driving for company business or company vehicles and use of cell phones and text messaging is important. Time off. Most companies have some policy regarding vacations or paid time off. There's a major legal difference between vacations and paid time off. You need to know the limits of how you can accrue either vacation or time off, and that you can't require people to forfeit benefits that they have earned through their work, which is how we consider vacations. But if you include in your paid time off policies other than what would have been regular vacations, such as sick time, holidays, even bereavement leave, that becomes then a vested right that has to be paid out to an employee on termination. So how you write your policies becomes very important. Also, do you have maximum accruals, or do you just allow people to accrue the benefits and carry over from one year to the next? And realize accrued benefits must be paid at time of termination, which if you're firing an employee means on their last day of work. If they voluntarily quit, you have 72 hours. But these are things to think about when you're writing your employee handbook. The disciplinary policies. Do you want to state and commit to a progressive discipline? If doing this, you want to make sure that you can still do what you need to do to manage your business carefully, so that limitations on when progressive discipline is needed and when it's not is important. Also, some companies, particularly unionized companies, have what we call a just cause policy, which means we can't fire you at will, but we can only do so for just cause. And then what's the process involved to deal with that and make that decision? Another part of this is disciplinary, probationary periods or new hire periods. They're a good idea. They're helpful to clarify expectations. They're helpful in terms of onboarding employees. They're useful if you want to decide who is going to be eligible for employee benefits, such as health insurance. But how you handle probation or new hire periods is important. Some additional information. Access to personnel files is lawful, and it's the best practice to have a policy that explains to employees what their rights are and how to go about obtaining their personnel files. Otherwise, you're left to demands from lawyers and unnecessary confusion. I think it's important that you keep employee addresses and contacts up to date, and stating that in your handbook is important. How to keep and report working time is important, whether you have an automated time system, a manual system, some other way, how you do timekeeping, because it's the employer's responsibility to keep time reports. How do you ask the employees to give you that information so that you can do it? Employee benefits are important and should be itemized but not covered extensively. We'll talk a little more about that. And safety. It's very important that employees report any injuries that they see, not only for themselves or coworkers, and that they report work hazards. And it's also helpful to tell employees what their workers' comp benefits are, including if you use a medical provider network, which means that you restrict what medical care an employee can have if they're claiming a work injury. It's important, we think, to have a policy on employee privacy of their personal information. You may or may not be covered by one of several California laws now under the California Right of Privacy Act. But it's a good idea to think through what personal information you're obtaining from employees and how it's maintained, and putting in a policy. That way, if you are covered by the law, by either the size of your business or the number of records that you maintain, or if you buy and sell personal data, you're complying with the right of privacy laws. And those are important and expanding for January 2023. Policy regarding benefits and safety. We would suggest you have an overview of what your benefits are, because frankly, employees may not think when they need it of what your benefits are. And your supervisors may not know, your own staff may not know. So we think it's important to tell people somewhat your policies on benefits, but not go into extensive detail. For example, in a health insurance program, you can either have what we call a summary plan description or a benefits booklet from the insurer. 401k plan has its own documents that relate to it. If you have other benefits such as dental, vision, prescription drug benefits, voluntary benefits, which employees can buy, such as cancer insurance, identify for your employees what those are. Regarding safety, you need to have a written safety manual we call the Illness and Prevention Plan in California. It's still one of the most common violations that Cal OSHA finds of employers. But now it's important to state that an employee has a right to see or obtain a copy of your IIPP, as well as information about personal protective equipment, which would include masks, face masks, protective eyewear, so on. And if you're dealing with hazardous materials, how they can obtain information about safety data sheets, which describe the use and danger of those chemicals. Now, at this point, you still need to have a written COVID policy. And we're just guessing, but I'm going to be forecast that we'll still need to have some type of COVID policies after January 1st, 2023. If you have workers who work outside, you need to have a written heat illness prevention program. And you need, we think, a way for employees and encourage them and hold them accountable for reporting injuries and work hazards. There's a lot of types of leave. The first one, bereavement leave, is new because it is now a specific provision under California law if you have 5 or more employees. Family medical leave applies if you have employees who cannot work because of they're caring for coworkers, and that's a benefit that's provided by ADD. There's also the California Family Rights Act, which gives people time off for illness for themselves and their employees. How that plays out and when you must use paid time and when you can use unpaid time becomes important. We recommend that you have a policy that lets people request personal leave, meaning just because they need time away from work. It would be subject to approval and would be unpaid, but it can be very helpful in dealing with the realities of human experience and problems that people and their families encounter. If you have 5 or more employees, you need to have a pregnancy leave policy. California requires military leave and other leaves related to a deployment for employees, and so that becomes a written process. California requires leave for employees, unpaid leave, to arrange and take care of childcare, and if their child care closes, as well as participate in school activities. And there's several different policies that relate to time off unpaid for victims of crime, sexual assault, and domestic violence. And then there's the issue of jury duty and witness pay. Most of these are not paid leave, but they become important because they tell us who's entitled to it and how to request it. We strongly recommend you use some kind of written request for leave form because it's very difficult for any human resources or company manager to know what the specifics of why a person needs time off and whether they're entitled to some, more, how much, when they need to return, and so on. And it's best to have that covered by your policies. Conduct and pay policies. So dress code and grooming can be important, and some employees have had a lot of difficulty in recent times because we become a less casual society in dealing with these issues, which can be a problem for coworkers and a problem for dealing with customers. And how you deal with facial hair, tattoos, and piercing becomes important. You realize there are some personal liberties or protections for employees in this as well. Many people want to have a complaint process or open door policy, and this can be helpful to deal with claims of retaliation because you want to encourage people who have concerns to come forward. In terms of pay and promotion, what are your work hours? What is your overtime policy? What is your work week? When do you issue paydays? Do you have bonuses? Are they voluntary or are they planned? If you have a commission agreement, realize in California, commission agreements need to be in writing. A new one that we now react to is pay scales and availability of information about pay scales. As of January, all employers need to be able to tell an employee who requests what the pay scale is for their job. If you have 15 or more employees, you need to post pay scales in any job recruiting activity or employment offering that you're making. And if you have over 100 employers, you need to fill out in May of next year a very detailed report of your pay scales, and pay by ethnic group, job classification, and salary or pay level. So this isn't a program on the new pay disclosure laws, but just a reminder that's important, and you can think about that and you do your handbook. Also, how do you handle reimbursement of business expenses? Technology. How do you handle online conduct and social media? Dealing with confidentiality, embarrassment, and client relations. What about internet and email use, and who owns it? Who can use a company machine? Who can use a company email address? Is it limited to working time or any time? And also respecting copyright rules. Realize that 75% of ransomware attacks, which are now increasingly common, are triggered by an employee responding to a phishing message on email. So they're inviting these ransom attacks sometimes into your own computer system. So how you handle that becomes important. Also, into the technology area, cell phones, and prohibiting use of cell phones while driving, and also whether you want to limit or not use of cell phones during working time, and paying when a person uses their personal phone for business use. There are certain things that you should not put in your employee handbook that are very important. One is arbitration of employment disputes. We said at the early part of this presentation how much employee lawsuits cost, hundreds of thousands of dollars, easily $50,000 to $60,000, even if you win and get it dismissed early. To the extent you can divert things from lawsuits to a private arbitration process, it's both quicker and cheaper to handle. But to do so, there are certain rules that you need to follow for arbitration agreements to be effective. Putting them in an employee handbook makes it very difficult to obtain the compliance that you need to be able to have a sustainable arbitration agreement. Also, if your company trade secrets or business information is very important, you might want to consider a separate agreement on that, which defines more that issue, who owns the information that's produced, how to handle it when an employee leaves, that certain rights don't end just because an employee leaves your employment. As a recap, a handbook is a way to think through and communicate your company policies, what employees can expect from you, what you expect of them. This is particularly helpful with regard to being on time and showing up for work. How can CalWorks Safety and HR help you? We can prepare and review your employee handbook. In fact, we offer to review all of our clients, or for others, their employee handbooks. We also have prototypes that we prepared that do all of these legal compliance steps and make it easier to do what you need to do for a handbook. We think it's important that supervisors and employees know what the policies are, so we can help with orientation or training sessions to tell people what the policies are. We can review and update your handbook, and we recommend this be done annually because courts change things, laws change, and it sneaks up on you. And if you go a year or two without updating your handbook, you're going to be surprised that you're either covered by obligations you didn't know about or failed to take advantage of some protections that were available. We can also present today's session, this webcast on current employment issues, on the third Thursday of every month. This is our December issue. In the first of the year, we're going to be talking about issues such as cybersecurity, also posters and notices. realize that there are at least 8 changes in the notices and posters that you have to place on your work site, either electronically or in paper every year. We're here to help, and we'd like to be of any assistance to you that we can. So if there are any questions, be glad to try and help.
All right, so let's go ahead and go through the chat. First question is, Dondra said bereavement of up to 5 days. What is the law and what are our options as employers?
Okay, if you have 5 or more employees need to have time off for the death of a family member. And that includes time for perhaps travel, for making final arrangements for funeral services, and it's unpaid time. So one of our suggestions is that you have a written policy that expressly deals with this and tells employees how to request it so that you can be aware of it and make sure that it's legitimate. And it's not the 3rd time the same great aunt died that they just want time off for. But it's a policy that only presents problems if you haven't thought through and been specific about what to do.
We are implementing a tighter dress code in our production area and need guidance on how to implement this change. Example, a lot of female staff wear leggings/yoga pants. We are requiring that they wear a more protective pant such as Dickies, Dockers, or scrub pants. What is our responsibility in this process?
Okay, so basically, if you're dealing with issues such as female attire that's different than other employees, you have potential discrimination claims. So it's very important that you think through what your policies are and why they're important from a business or safety standpoint. And then part of your safety plan should include an assessment of hazards. So what are the hazards that you're trying to prevent, and what are the reasons that you're implementing it? This is an area where one of our safety consultants or our HR consultant can be helpful. But it sounds to me as if particularly this may be a safety assessment issue, and explaining to employees the importance of their health and safety is a good starting point on why you're making changes. You don't want to get in an argument about fashion, but you do want to get in an argument about health and safety and going home with all of your arms and limbs attached.
What is a pay scale?
That's a good question, and we don't have definitive regulations, but basically a pay scale is a range of pay that you are currently paying or would prepare to pay employees. So if you're a small employer and you only have to provide this information to current employees who request it, you can limit your pay scale, break down your jobs. And to me, if you're a large employer, you may be experienced with this. If you're a government employer or a government contractor, you may be familiar with it. Many smaller employers haven't dealt with this in the past. My suggestion is I'd start with a report of what I currently pay employees. And you'll see when we do this, as we call sometimes a pay ranking study, you'll see natural breaks where there are groups of employees that are paid, let's say, the new minimum wage in California starting January 1 is $15.50 an hour. So your range may be $15.50 to $20, $20 to $25, $25 to $30. Ranges can overlap, by the way. They don't have to be exclusive. So you could have a range from 15 to 25, 20 to 30, et cetera. Don't follow Chase Bank's proposal. New York has a similar law to California's, and Chase Bank said their pay scale was $20,000 a year to $2 million a year. That didn't work. That was too loose and too ill-defined. So the best thing I can suggest is that you sit down and start with what are we really paying our employees now, and are we having certain categories like introductory employees, experienced employees, lead employees, technical employees, sales, et cetera. And just look at what your current practices are and how you would describe them to create a pay scale. It's something that doesn't have to be a big, difficult process, but it does need to be done.
This is a follow up to the earlier question. We currently offer 2 days bereavement pay. Should we be offering 5 days unpaid then?
The law does not require you in California, nor federal law requires paid bereavement leave. Because of the difficulty of getting workers and the fact that there's still a shortage of good workers, I'm not eager to recommend that you'd abolish your policy on paid time. But what you could easily do to comply with the law is to expand it to say we provide bereavement leave if you need time off, 2 days paid, and the balance up to 5 days, would the extra 3 days, if you need it, would be unpaid. I don't think that I would switch from 2 days paid to 5 days unpaid, only because it's not going to be received well by the employees. And it's not frequently used, but it is important that it be clear.
How does an employer deal with the pay scales when they have long-term employees who have received increases due to seniority, which makes the gap in the range larger than it probably should be?
So one of the ways to handle this is how you define your groups. So you can have, for example, employees 1, employee 2, employees 3, or senior technical experts, and it all depends on. So I would sit down and describe it. But I will tell you, my experience has been often there's more of a problem between a disparity between new and long-term employees, because long-term employees have worked you for quite a while. But when you're hiring new people, you have to pay competitive current market rates. So you may be surprised that you're paying new employees more or disproportionately more than longer term employees who are critical to your business, which is one of the reasons it makes sense to do this pay ranking study, just to see where you are. Don't do it by guess, do it by facts. And then you can adjust it. And it's easily possible to have definitions such as senior employee, beginning employee, whatever terms work for your business. You can have entry-level jobs that are paid less than people who have worked and qualified by their experience and demonstration. Or you can have different levels where people can be promoted from time to time if their contribution to the business justifies it. And the other part, which we're not sure since it's a new law, is how much will there be a request? How many people will actually request for information about the pay scales? But if you're recruiting, you have to disclose it, and be aware if you're recruiting for a position using public media or platforms and so on, it's entirely possible your current workforce will know what your recruiting offers are. So you need to think about that when you're formulating your policy and your approach.
All right. I don't see any other questions in the chat. Thank you, Don. This is an important topic. And remember, if we didn't address your question today, go ahead and reach out to us at info@calworksafetyhr.com. Again, please be on the lookout for future topics on our website at calworksafety.com. Thank you for joining us, and have a wonderful rest of your day.